start again because I didn't have it turned on properly. So I apologize. So welcome again to those in the room, and to those of you on the webinar, welcome also. We will try to have time for questions from everybody, both in the room and on the webinar, a little bit later. For those of you on the webinar, there's a drop-down box for your questions, and you can hit that box and then send your questions, and I'll be watching for them. For those of you in the room, I'm not being rude with the computer. I'm looking at the webinar questions so that we can try to respond to them a little bit later. So again, I'm Steve Vermiel. I'm the chair of the ABA section of Civil Rights and Social Justice First Amendment Committee. We have been doing these hot topics panels for about 3 years. I think this is the 6th one. When we started, it was just hot topics on free speech. For reasons that probably need no explanation, we have expanded the title to Hot Topics on Free Speech and Free Press. We have a number of things that we would like to talk about, and I'll get each of the panelists involved in those topics, and then we will turn to your questions and expand the pool of subjects. Joining me tonight, a veteran of these panels, return player, Bob Corn-Revere, who is one of the premier First Amendment litigators in the country. He's a lawyer at the firm of Davis, Wright, Tremaine. He has argued First Amendment cases all over the country, in all kinds of courts, and is extremely knowledgeable and experienced. And I'm delighted that he's back with us again. Next to Bob is Nott, who is the executive director of the Freedom Forum Institute's First Amendment Center, also an experienced First Amendment expert, and doing great work making the Freedom Forum a focal point for discussion of free press and free speech issues. And then next to Lata is Scott Michelman, who is the co-legal director of the ACLU, American Civil Liberties Union of DC, a position he's been in for a couple of years. Scott is also a very experienced civil rights, civil liberties litigator, including free speech and free press issues around the country. So we have a wonderful panel. Each of our panelists has sort of taken on one topic for starters, and then we'll talk briefly about some of those, and then expand the pool, as I said, to other subjects. Bob, why don't you start with a wonderful recent controversy over White House press passes? And is there a First Amendment right to a White House press pass? The court decision so far was based on due process issues. But what about the First Amendment?
But due process tinged with First Amendment issues.
Tell us about that.
This was the revocation of Jim Acosta's press pass. They call it the hard pass for access to the White House. People who are veteran members of the White House Press Corps have a more or less of a permanent press pass, so that when they periodically go to the White House, which used to be a daily briefing, but under this administration it's like whenever, they have semi-regular briefings. Members of the press can go in without having to go through the whole credentialing process for each one. So having that hard pass taken away is quite a big deal for an individual. This recent controversy is sort of part of what is a larger controversy that John Oliver generally lumps under the term of stupid Watergate, in that this administration has been famous for its disdain for the press, starting with Donald Trump as a candidate before he became president, talking about how there's a need to open up the libel laws, whatever that means, and calling any unfavorable news coverage fake news, and on and on. You've heard the whole litany of it in everyday tweets. This is one of those examples of where that took on a tangible form, in that there was actual action and not just mindless talk. And the press pass was taken away. In the midst of the press conference, Donald Trump told Jim Acosta he was a terrible person, and next thing you know, his hard pass is taken away. As it turns out, this is something that has come up before in somewhat different context. There was a decision that reached the D.C. Circuit in the late 70s involving a writer named Robert Sherrill. And the decision in that case was that where you have the taking away of a press credential, because it does have a connection to First Amendment rights, that due process must be provided, that there has to be prescribed guidelines, there has to be notice in advance of the press credential being taken away, and an opportunity to respond, none of which was provided in this case. CNN took it to court and got an immediate hearing. And the decision, which actually it isn't a written decision, but there was a ruling from the bench that disposed of the matter. And basically the court said that, whether or not I agree with it, the precedent in this circuit says that if you aren't provided with due process, then the revocation was invalid. It does talk about how that is infused with a First Amendment interest, but the court was quite clear in saying that it wasn't going to decide the merits of the First Amendment claim. In other words, it wasn't going to decide to what extent there is a First Amendment right of access to the White House. The general understanding is, while the White House is not obligated by the First Amendment to have daily press briefings or periodic press briefings of any kind, once they open up the White House for that purpose, they can't then arbitrarily deny press credentials to someone simply because they don't like the questions they ask or they don't like the tenor of the reporting overall. So having gotten the press pass back, CNN dropped the case. At least that case is not going to resolve this First Amendment question. And the White House has said it's going to issue new guidelines. We have yet to see them in writing, but they say that they're going to be limited to one question and no follow-up questions. So we'll see how well that works.
So we don't know whether we'll get a First Amendment decision on access to the White House.
Not in that case, but there was another case filed in October by Penn America Center versus Trump, and this talks about a lot of the broader issues where you have basically the president announcing his motives for why he does things and says things about the press. You have that then followed up in a number of concrete actions. So, for example, he disparages the Washington Post, and then next thing you know, there is an executive order raising postal rates that distinctly affects Amazon. Jeff Bezos, who started Amazon, owns the Washington Post, and Trump has made no bones about the fact that he wants to go after Jeff Bezos. There is the Justice Department challenging the AT&T Time Warner merger because Time Warner owns CNN, and claiming that there is an antitrust case there, in using a theory that the Justice Department never follows in mergers of this type. And you have a series of things like that, threatening to revoke broadcast licenses, although the president is saying that in response to talking usually about cable channels, which are not licensed by the FCC, but it's close enough for this administration. In any event, these issues continue in another form, and we may see courts ultimately getting to those issues in that litigation.
All right, thanks. Lata, Scott, no way in? Or?
Oh, that's a pretty thorough coverage. But I think what you were saying, so the Pan America case, do you think that will actually, they'll actually touch upon the First Amendment issue?
I hope so, because I just signed on to it.
One of the things that strikes me about this series of cases around where statements by the president give rise to a countervailing First Amendment interest is you're in an area where two incidents of speech are bumping up against each other, and so it's interesting that I think what really takes it over the line is that Donald Trump has been so explicit about his motives in using the fact that coverage is critical of him to take these retaliatory actions. But absent these very directed actions, these very clear statements of motive, I think a lot of courts would otherwise be reluctant to intervene because usually it's just the president speaking his mind. I mean, he wants to call Jim Acosta a terrible person or whatever, he can do that.
Yeah.
And so what I think is interesting and novel about this moment in First Amendment law is we're going to get a lot of controversies acutely raised of a type that we don't usually get because presidents aren't so blunt, so retaliatory, and so sort of dismissive of First Amendment values that they don't mind saying, look, I don't like the Washington Post, I'm going to go after Amazon, which is basically what he said.
And you do see efforts to sort of get at speech issues without actually like using the First Amendment, like when the president was upset that Facebook or Twitter were shadow banning conservatives or conservative content, in his tweets he brought up using antitrust law, which would have no effect on the content, but would be sort of a retaliatory action.
For his critics who have security clearances, revoking security clearances for his critics. I mean, it's obviously a punishment for critical speech. But it does raise a really interesting First Amendment issue. We've seen this in some other cases where you'll have a public official either making statements or whatever, and then they will defend their actions by saying, well, I have a First Amendment right too, which is true as individuals, but as the government, and when they're speaking for the government, it's important to remember that individuals have rights, governments have powers. Governments don't have rights, and rights always trump powers when you find that the use of power is infringing on someone's individual right. So when the president is simply tweeting something like, I hate Jim Acosta or whatever, fine. When he takes action as the head of the government, that is not his speech. That is not him acting as an individual, as him acting as a government entity, as the head of the executive branch. And that's where rights provide a limit to that. And so you're right. I mean, it's going to be difficult to necessarily parse out when one is purely an exercise of power versus simply talk. And, frankly, when Trump says, let's open up the libel laws, if you can figure out what that means, that by itself doesn't really do anything. It's not an exercise of power. But when he starts issuing executive orders or doing other things that have tangible effects, that's an entirely different thing.
Like using powers that he actually has.
Yeah.
I want to move on to Lata in a second, but something you mentioned I've been curious about. Is there a potential First Amendment discrimination claim in the Time Warner merger being blocked, but the ABC merger being allowed to go through? The White House likes the content of the organizations involved in one merger better than the content in the other merger?
Sure, there's always a potential for that. The difficulty is proving it.
Right. You'd have to have a hard time finding motive.
Right. But that's the thing about the fact that Trump is so willing to say what his motive is. Because in any First Amendment retaliation claim, the first step, the hurdle that you have to get over, is linking motive and action. And here, he does it for you.
Right, and in that sense, I see a real parallel between these cases and the Muslim ban series of cases, where you had such statements of motive as have basically never been said by presidents, at least in modern history, since the Bill of Rights was sort of invigorated in the early part of the 20th century. So you had the type of claim going forward that would have been impossible without evidence from the president's own mouth. So in some sense, he's his worst enemy. Yeah. And if he just kept quiet about it and sort of did the things he wanted to do a little more carefully, it would be much harder to sniff out that unlawful motive.
And that's what presidents have done in the past. And you only find out about it decades later when people write books about what went on inside the White House. So, for example, FDR ordered a press audit of the New York Times. A tax audit of the New York Times because he didn't like the coverage. And he also went after the Chicago Tribune because he thought they were Nazi sympathizers. There were a number of actions like that. The Kennedy White House initiated a series of fairness-doctrine complaints and sort of did back-channel funding fairness-doctrine complaints against right-wing radio personalities. Nixon, of course, went after the Washington Post's television licenses because he didn't like their coverage. But they're never stupid enough to talk about it in public. And so they don't turn into cases, or, you read about them in history books later. But here, you have kind of like full disclosure up front.
All right, well, let's turn to Lata. You started to mention social media and Facebook and Twitter and so on. Tell us a little bit about some of the issues coming up in the use of social media accounts by government officials and subpoenaing social media records and so on.
So what's really interesting about all the legal issues that are surrounding social media is that you have these basic First Amendment principles, and one is that the First Amendment applies to public entities, to government entities, and not private entities. And another is that the most protected forms of speech are political speech on matters of public concern. Other types of speech are protected, but less so. But then with the internet, with social media, it really does blur the line between private and public entities, and between what's a private matter and what's a public matter, or a matter of public concern. And you see that with, for instance, with the president calling for Facebook and Twitter and other platforms like that to be regulated so that they allow both conservative and liberal content equally, or whatever his claim was. But basically, you have things like that. You also have people on both sides of the aisle saying that these companies need to be regulated because they're so integral to how we have public conversations, how information is distributed, shaping the narrative around so many issues. And so it's strange because they are private companies, but more and more people are calling for the government, for someone to step in and basically oversee how they regulate their content. And I mean, that's interesting because the First Amendment applies to, just as it applies to the president, it applies to large companies as well, and they have the right to determine what kind of content appears on their platforms. But you can also see that there have been times when the government has been able to regulate the speech or the content produced by private entities. That can happen if, say, they decide that Facebook or Twitter are public utilities, like they're like water companies or electric companies. That could happen. I mean, the most prominent case of that I can think of is there used to be a doctrine called the Fairness Doctrine. When broadcast channels were, when every television station, radio station was broadcast and there was no cable, the doctrine came about because there were only a limited number of channels to distribute information to the public. And the idea was that if this was the only way somebody was going to get information, you had to present both sides of an issue. And broadcasters found that to be a violation of their First Amendment rights. They didn't necessarily want to present a side of an issue if they completely disagreed with it. But at the time, the Supreme Court found that this was necessary. It was an infringement on free speech, but it was an essential one because essentially there's only a limited number. There's only a limited broadcast spectrum. There's only a limited number of broadcast TV and radio stations. And so the government could license them out. And therefore they had the right to say that their licensees had to do certain things, like present both sides or avoid profanity when children might be listening, that kind of thing. That really changed with cable because suddenly there weren't a limited number of channels. There were a lot of channels. And with the internet, of course, it's harder to apply some kind of reasoning like that. But I think it goes to show you that when the government really wants to regulate something, there are times when you can come up with a regime that will allow you to. So while I don't necessarily think we're going to get an internet fairness doctrine, we already see things like the Honest Ads Act, which some people do have free speech concerns about, but would essentially require that Facebook and Twitter track who's paying for political advertising, in some cases make sure that it's labeled. One provision of that is they have to try their ultimate best to avoid taking foreign money for political advertising. So you see that regulation is coming, and a lot of it is adjacent to content regulation, but it's getting there. The other thing that's interesting to think about is how the lines between public concerns and private matters are getting a little blurred. And one prominent case that we were talking about in our email chain leading up to this, recently the publisher of the Daily Stormer was sued by a woman who basically, because the publisher of the Stormer asked all of his followers to, I think he said something like release the troll army. Basically, he encouraged his readers to harass this woman, all because she's a real estate agent and she had some kind of real estate dispute with Richard Spencer's mother. And so she, her husband, and her 12-year-old son faced a ridiculous amount of harassment, ethnic slurs, just occasional death threats, all of that. And so she sued for intentional infliction of emotional distress and for invasion of privacy. And the defense that the Daily Stormer has is that, well, this is a First Amendment matter. That speech encouraging people to troll this woman protected by the First Amendment. But this case was just, the motion to dismiss was denied by the magistrate judge quite recently. And the reason that the judge put forth, which I think makes a lot of sense, is that, the motion to dismiss was saying, well, this is protected by the First Amendment. There's no case here. But this isn't really speech about a matter of public concern. It's really, and, the brief tried to make a case for it being a matter of public concern, but ultimately this is a public website that attacked a private person and asked people to harass a private individual whose relation to a matter of public concern is tenuous at best. Given that, she's a real estate agent who may have had dealings with Richard Spencer's mother, it's hard to see that de facto making the grade. And so you can see that, even though it may not be speech that falls into a particular category that is not protected by the First Amendment, it's something where you do have to weigh something that's not on a matter of public concern against, say, the harassment and invasion of privacy aspects of it. So there's just a couple of interesting things that you can see just when you look at the First Amendment in the context of social media. I could go on, but I don't want to take up the entire panel.
Thoughts, other ideas?
Well, this one blurs the line just a little bit, and it's one of the things that is a hallmark of what has become so difficult about applying traditional First Amendment protections in the Internet age. The dispute that led to all of this harassment, and one of the things, too, that makes this difficult is just how ugly and revolting the speech is, right? But yet the court actually found ugly and revolting, but not unprotected speech, that it was protected speech, but could be actionable because of the invasion of privacy aspects and all of that, and did so by finding that it was a private dispute. And yet, the realtor who was dealing with Richard Spencer's mother, Richard Spencer is this white supremacist who's been going around to college campuses around the country, called for a public boycott of Richard Spencer's mother and her business and everything. And so the argument, at least it's arguable, that she had already injected herself into a public controversy, so that it may not have been a purely private dispute, may not justify some maniac on a neo-Nazi website calling for a troll response.
But it might have been, they might have had a better case if the call to action on the website was like, this person's trying to boycott someone for no reason,
If it had been more substantive, that's right.
If it had been more substantive,
and that happens in First Amendment cases where if the speech is less substantive, you're going to find courts to be less sympathetic, like Morse versus Frederick, which was the school case where the guy held up the Long Hits for Jesus sign.
We have that at the museum. It's great.
Which, if he had had some answer for what deeper meaning he had for that, I think the court would have looked at it differently. But when asked, why did he hold up a Long Hits for Jesus sign, he said, I don't know.
He got it off a snowboard.
Yeah, that's right.
He wanted to be on TV.
That's right.
So I'm the aspect of the Montana case that I find really interesting is taking Bob's point about how this is a quasi or adjacent to a matter of public concern. Does that mean if the court had gone there and seen it that way, does that mean the troll storm or troll army is protected just because it's about a matter of public concern, or should the key to the case have been the way in which the speech was deployed and not actually either the content of the speech or the nature of the controversy, in the same way that, like, if you doesn't matter if you're calling to promote a candidate for president, if you call someone repeatedly at 2 a.m, that can be regulated. And so I wonder if we're at one of these points where the First Amendment, courts draw lots of lines in the First Amendment: the content-based line, the viewpoint-based line, time, place, and manner, public forum, public concern versus private concern, and they don't all line up. There aren't always neat boxes, and I wonder if a different set of boxes might have made this case come out in a more principled way.
Well,
I think that if the facts were just a little bit different, it would have been protected by the First Amendment, that call to action. I think it's interesting. They looked at a lot of things, like aside from the fact that it was private, it was considered a private matter, not a matter of public concern. Some of the followers or the readers of the Daily Stormer did respond with death threats and things like that. If that had not happened, it might have been a little bit different. If it had been, if the reaction had all been permissible speech, that might have been a little different.
Well, and there's a distinction between the call to action and what some of the individuals who responded to the call might have said and whether or not that was protected. But it does indicate the difficulty of sometimes, you're talking about putting things in different boxes, applying these new facts to, the way the internet works with traditional First Amendment protection. So, for example, and it's important to keep in mind that this is a very early stage of litigation. No decisions have been made on the merits of the case, just that it could go forward. But one of the traditional civil rights cases that is at least applicable to this kind of situation is NAACP versus Claiborne Hardware, which said that people who were inciting boycotts and sometimes using really pretty, almost calls to violence in calling for boycotts of segregated stores, the Supreme Court held that speech was protected, even if sometimes some of that speech crossed the line. And that's sort of the category that a case like this falls into. And what's difficulty is deciding a case like this where the speech is so repellent and it's impossible to defend the speech itself, and yet you've still got to defend what I think is the centerpiece of the First Amendment, and that's its neutrality, that it doesn't choose sides between meritorious speech or non-meritorious speech, or one political persuasion or another one. It's got to be neutral.
And that's where, in the Montana case, you had the magistrate judge bringing up that case and saying, well, the difference here is that was a public matter and this is a private matter, and no one, although the NAACP case featured a speaker who was, sometimes saying, like, if people aren't boycotting these businesses, then you take action that's close to illegal and violent. The magistrate judge
break their necks.
Yeah. But the magistrate judge said, well, this is different because, like, in that case, nobody actually did go ahead and break necks. So that's it's a distinction that I'm not sure if that actually works for me, but, like, I can see that, like, when you're balancing these interests, the public and private thing, and then the actual consequences of the action come out as well. It also made me think of Snyder v. Phelps, which, if you guys remember, is the case with the Westboro Baptist Church. They gathered outside of funerals with horrific signs. And in the case that made it to the Supreme Court was actually also an intentional infliction of emotional distress case. It was, the family of a soldier, and at his funeral, the Westboro Baptist Church showed up with their signs. Obviously, that was the cause of a lot of emotional distress, in the same way that this case with the Daily Stormer is. But the way that the Supreme Court drew the line there was that if the signs had been positive rather than negative signs, then the speech would have been allowed, and therefore allowing this tort relief against the Westboro Baptist Church for this speech was viewpoint discrimination. It depended on what they had to say, as opposed to just them being there saying something.
But it also very broadly interpreted what is a matter of public concern. And here you have these, cult figures from a little family cult in Kansas coming out to the East Coast with their hateful signs, picketing on the roadside next to where a funeral was taking place. It's easy to make the argument in a case like that that's a purely private matter, and yet the issues on their signs spoke to what was in their doctrine, broader public issues. And so, again, it's a question of, if you are going to maintain those principles, do you make an exception when it happens to be Nazis?
So aren't you all raising a larger question, which is, although speech about a matter of public concern has been a good standard for speech and free press, have we ever really known what it meant? It grows out of defamation law, but does anybody really know what it means?
You'd be the guy to answer that question.
I don't know what it means. I mean, the standard joke is if it's a press case, speech about a matter of public concern is whatever the press wrote about because they made it a matter of public concern. But that can't really be the right answer.
And I think the public concern test has sort of jumped categories. I mean, it jumped out of defamation. It showed up in the Snyder case. It showed up or it's shown up for a very long time now in public employee speech cases, where the employee speech on a matter of public concern as opposed to a private grievance is a key element of showing that the speech is protected to begin with. So it has been an important category, and I think not enough attention has been paid to what it means. But I do wonder if a more a type of line drawing that focuses more on manner of speech, that is, harassing speech that is like, that is akin to the 2 a.m. phone call, that is akin to a threat, regardless of what it says. It could say, we hate you because you're a Jew, we hate you because you're a white person, we hate you for whatever reason, we hate you. Doesn't matter. Or even, we love you, but we're going to call you at 2 a.m. because we're jerks. And we're not, we're not very polite. That seems to me a more defensible line than this nebulous public.
Isn't harassment also kind of a nebulous standard? Like, what is your commentary versus what is reaching the level of?
No, I think that's right, but I think there's probably a larger body of law defining what harassment is, what intentional infliction of emotional distress is, what each of these torts is under state laws than there is in the First Amendment context, saying what a matter of public concern is, in the same way that the standards are fairly clear about what's defamation. And there's a lot of law on defamation, which has been infused importantly by the Supreme Court with a First Amendment limitation, but which, defamation claims aren't dead. They're just very difficult to bring, as they should be. And so I wonder if there's an analogous type of limitation that could be placed that would allow claims to go forward on a basis that doesn't require either an examination of content, whether they're Nazis or they're not Nazis, or a nebulous and sort of hard to pin down.
I think that's very difficult to do if you're talking about content versus conduct. The 3 a.m. phone call is an easy case. Section 223 of the Communications Act deals with that, and it even says to cause someone's phone to repeatedly ring and disturb their peace. That is something that is akin to conduct. It is conduct that can be regulated, and it's not going to be protected as speech. But if you're going to say your opinion is so repulsive, your opinion is so harsh that it's akin to being called at 3 a.m, that's very dangerous territory, because then what you're saying is that some speech we simply consider to be too outrageous. And by the way, the court has dealt with that issue in numerous cases, including the Falwell case, saying that's just not a standard that anyone can really understand and apply. And so if it's conduct-based, that's a little easier than if you're trying to create a content standard for what is beyond the pale.
So, question for you guys: what do you think of the practice of doxing, which is basically taking people's their email addresses, phone numbers, home addresses, and posting them online? I mean, I would say that at that point, while there could be a question of like, I wonder what they intend to do there. It's never anything good, just, for whatever reason you're doing it. Would you consider that more a conduct or content?
Well, I think that's a great example of how a conduct-based standard can be used to avoid exactly the concern that Bob raised. I mean, we have to be very careful to maintain the neutrality of the First Amendment, because if it doesn't work for one side, then it's ultimately not going to work for any side. But if instead you say we define whatever is tortious or whatever is unlawful by statute as the intentional release of a certain type of private information, in the same way consumer protection laws prohibit the printing of a certain number of credit card digits on your receipt. That's not about the content, and so I think it may be possible to have those definitions that relate to an activity I think everybody agrees is problematic at some level, regardless of whether it's used by the left or the right.
Yeah. I think the doxing example is something that we already have a doctrine for, and it's called invasion of privacy. If you're releasing private information about someone, at some point it does become actionable. The thing to keep in mind is that when you're talking about doxing and putting someone's information up saying you should contact that person, you're talking about posting information. And if it isn't private information, then it's kind of like saying write your congressman. It might involve private action instead of public controversy, and that's where we get into the issue in the Montana case. But if you're not revealing private facts and you're simply saying you're making it easier to contact a person to express your displeasure with them, it's hard for me to understand how simply posting information becomes something that you can punish.
Oh my God, we're just going to get to the public-private divide again. Because,
yeah.
of course, you would imagine that giving somebody information about how to contact their government officials or large companies, that seems okay, right?
Yeah.
But then you get to private individuals, and it becomes more murky. And
Yeah.
I guess we're doomed to come back to that over.
Maybe we will.
Well, as often happens, we have way too much to talk about. So I want to turn to Scott, because we do want to leave time for other subjects and for questions. We seem to be living, at least in some places, in which it's become fashionable to protesting. Talk a little bit about what's happening with the culture of protest, with the specific cases you're involved in, and
Sure. Yeah, it's a very dangerous time to be a protester in the United States. Perhaps more dangerous than at any time in recent memory, because of the aggressive actions taken by various actors, and the Trump administration is easy to single out, but it's not just the Trump administration. There have been state legislatures passing anti-protest bills. There was one state legislature that made it be easier to hit a protester with a car, or
North Carolina
provided less culpability. So it's a dangerous time, and it's born of the worst impulses and the least sort of free speech compatible impulses. The impulse of politicians to say, I don't like that speech, instead of answering it, instead of responding to it, instead of addressing its concerns, or ignoring it and counting on people to listen to it and make their own decisions in your favor. We're going to regulate it. We're going to stamp that out. We're going to make sure protesters can't do that. We're going to prosecute them. We're going to charge them money. We're going to restrict the areas in which they can protest. So I'll give you three examples recently here in the District of Columbia that have been sort of flashpoints for protest, all in the past 2 years. One is the National Park Service's recent proposal to charge protesters money for demonstrations. And they claim that they're being flooded with applications now and they can't process them. But in fact, our Freedom of Information Act request revealed that most of the applications that they're getting for activities in national parks in D.C. is actually for volleyball games. But they're saying, oh, we're being flooded. We need to charge money. In another, and so those proposed rules are in sort of up in the air right now. There's a new director of the National Park Service. We've submitted comments. A number of organizations have submitted comments expressing concern, and we hope these and related restrictions on areas in front of the White House and on structures used in protest will not be promulgated. Another well-known case is what happened on January 20th here in the district on Inauguration Day 2017. There were lots of protests. There were thousands of people all over the city marching, saying various different things about the inauguration. And there was a group that was subjected to a mass arrest after a much smaller number of people within or near the people who were arrested were committing acts of vandalism. And on the basis of a few people committing various acts of vandalism, the MPD, the Metropolitan Police Department, rounded up more than 200 people. The commander from the scene, the incident commander, has admitted he didn't distinguish between people who were protesting and people who were rioting. And what happened in the aftermath of those mass arrests, which came along with pepper spray and prolonged confinement in unconstitutional conditions and felony charge. What happened in the aftermath was that more than 200 people faced decades in prison due to various felony charges, destruction of property, conspiracy, et cetera, that were stacked up by the U.S. Attorney's Office. Ultimately, although a few people did, maybe a dozen or slightly more people did plead to charges, reason ultimately won out, and in a couple of trials, one in late 2017, one in 2018, groups of protesters were acquitted of these rioting charges. The government was sanctioned for various instances of prosecutorial misconduct, and ultimately the government dropped all the cases. So nearly 200 out of the 220 odd people who were prosecuted ended up either being acquitted or having their cases dropped. But so, good outcome, win for the criminal justice system in the sort of broader sense of the juries asserting their independent judgment, but an incredible chilling effect when the price of coming out to protest might be if somebody near you breaks a window or knocks over a newspaper box, then the cops swoop down on you, pepper spray, arrest, prosecution. In some cases, in most of the cases, folks were prosecuted for anywhere from 9 or 10 months to 18 months while they waited for these charges to resolve. They waited for the trials to happen. Ultimately, the charges were dropped just this past summer. And meanwhile, these people from all over the country who came to the district to protest this singular event, the inauguration of a president, are having to spend their own money on lawyers and to travel back to D.C. for court hearing after court hearing, facing the anxiety and uncertainty of all these decades in prison. So serious questions about the conduct of the police and the conduct of the prosecutors in going so hard after so many people merely in the vicinity of some vandalism. It gives rise to a significant chilling effect. And the last example I'll give is related to that investigation, but different, and ties in with the issue Lata raised of social media, is you had warrants issued to Facebook in conjunction with the government's investigation of the January 20th events. And these warrants sought personal information covering a period of 90 days for individual political activists who were not themselves defendants, who were not charged with any crime, who were not necessarily witnesses or co-conspirators. They didn't know. All they knew is that they were Facebook was issued orders to turn over all the content of their account for 90 days. So that's their personal photographs, their personal communications, any organizing, any political activity they did, events they went to, events they organized, even ones having nothing to do with January 20th itself. And so another sort of dangerous moment for protest meeting social media, as it started to be people's online associations that were in jeopardy. their personal stories, their associations, what groups they liked, what protests they participated in. Ultimately, the Superior Court here in D.C. Helpfully cabined what the government could ask for, imposed some safeguards, and as we were continuing to litigate whether those safeguards were enough, the government declined to try to enforce the warrants as modified, and ultimately the cases were dropped and became moot. But another sort of chilling moment where people on Facebook have to be thinking, well, if I'm using Facebook, which is a great organizing tool, is the government going to be looking into who I'm talking to, what we're talking about, the opinions we're expressing, the events we're going to and organizing? And so again, you have this moment in our country where protest is, in some very real senses, under attack by official channels.
And you can see that chilling effect also in some of the state laws that have been proposed. I'm thinking particularly like in Louisiana and Minnesota, where you have these laws that they're kind of inspired by the Dakota Access Pipeline protests. So they make it is already a crime to trespass on critical infrastructure or government property, but they make it an extra super crime to do so. And then with very severe sentences, prison time. And so they also make it, in Louisiana, I believe, conspiring to commit protest on critical infrastructure is a felony. Aiding and abetting a protester, what does that mean? Is also it's a felony, and it just
If you like it.
Right, if you like it on Facebook, if you give a protester a bottle of water on his way to the critical infrastructure, I don't know. And but it's the fact that it's hard to figure out exactly what that means. And I sat down with a couple of lawyers and tried to work it out, and we just couldn't. And the fact that that's hard makes it, you can see the chilling effect. You'd be hesitant to do anything involved with a protest. You'd be worried that, well, we're supposed to protest next to the critical infrastructure, but what if one person or group actually trespasses? You know, there's just too much up in the air. There's too much to risk when you're not really sure what the law is there. And you also don't need to pass bills that make something that was already a crime, a super crime.
Let me pose a question that's on the webcast, just Scott, because it sort of relates to what you're talking about. Some of the protesters, I guess, were accused of vandalism. The questioner is asking, is it the public's duty to stop others from vandalizing?
Well, it might be nice, but it is not your duty under penalty of criminal activity yourself. One of the prosecutors' theories and one of their big arguments that they made at the trials was these people are guilty because when they saw windows breaking, they failed to leave. That they had an affirmative duty to disassociate themselves from or even just sort of get out of there. First of all, that would have been highly impractical because during a good chunk of the protest, the DC police were actually funneling protesters into particular streets that they had determined would be where they would kettle the protesters, where they would corral them, and using pepper spray to enforce that. So it was, in many cases, simply physically impossible to leave, or they would have risked assault on an officer had they done so. But more fundamentally, guilt is personal. Guilt is not associational. And so as much as we might say as a good person, maybe you might go up to somebody who's breaking the law and say, it would be so much more effective and law abiding, and you'd have so much moral authority on your side if you raise your voice instead of bringing your hammer down. But that's not something that you have a responsibility to do, and in fact you have a First Amendment right to continue protesting even when others may be breaking the law.
All right. I want to turn to questions in a few minutes, but I had a couple other things I thought it would be great for us to get to before we do that. One is, of course, one of the big First Amendment issues we were all watching a year ago or last spring was the Masterpiece Cake Shop decision from the Supreme Court, the bakers in Colorado who didn't want to provide a wedding cake to a same-sex marriage. And the expectation was that the court might say all kinds of very significant things about the balance between free speech and civil rights laws, or perhaps freedom of religion and free speech and civil rights laws. The court issued a somewhat narrower ruling, basically saying that the Colorado courts and the Colorado Civil Rights Commission had basically discriminated against people's religious beliefs, and so they could decide the case on that basis without really deciding any of the potentially big free speech issues. Is the baker engaging in free expression? Does his interest in free expression outweigh civil rights claims, and so on? There's at least one case that's already pending at the Supreme Court involving more or less the same situation, but from Oregon, involving a bake shop in which the bakers said they would not provide a wedding cake to a same-sex marriage. But in their cert petition to the Supreme Court, they raise a lot of free speech claims as well as free exercise of religion claims. Do we think this is the sequel? Will the court get to the free speech issues in this case? Will they pass on this one and wait for another one and let it breathe for a while? What do we think?
I mean, it seemed like the court was going out of its way not to resolve the chief masterpiece. So if I had to bet money, I'd say that they won't grant cert on this.
Any other wagers?
Well, it's hard to say. I mean, having filed an amicus brief in the Masterpiece Cake Shop case on behalf or in support of the baker, but for an organization that supported both gay marriage in the Obergefell decision, but also supported the First Amendment rights of the baker. These are very difficult cases for the reasons that it's hard to decide them in favor of the state public accommodation laws and ignore the First Amendment issues at the same time. First of all, it's important to divide what First Amendment issues you're talking about. If it's simply the free exercise argument, then I think that the Supreme Court dealt with that in the Smith case. If simply saying you believe in a certain religion allows you to ignore public accommodation laws, then you've essentially eliminated the force of those laws. It means any bigot with a Bible or a Quran can simply say, I don't want to serve you. On the other hand, if you're dealing with a kind of a business where art is inherent to your business, then you're talking about two very important First Amendment issues that historically the ACLU has supported. One is very broad interpretation for what kind of art is protected, or for, to put it more bluntly, is art protected by the First Amendment, and can baking be part of it? And that was sort of the underlying First Amendment question. And then the second one is that if you accept the idea that the First Amendment should be interpreted broadly enough to include all kinds of symbolic speech, then can you force someone to create a work of art? In other words, can you compel a creative work? Now, I don't know of any decision that has ever said that that can be done. And the Supreme Court addressed that in the context of the Hurley case, looking at the Massachusetts public accommodation laws and whether or not you could force a parade to permit to include marchers, in that case gay and lesbian marchers that they didn't want to include. And again, the court said that it can be amorphous speech, it can be symbolic speech, it's protected, and we can't force someone to do that. So, as I say, they're difficult cases for a lot of reasons. I have friends and colleagues who take a very different position on it. But they are not easy cases. And to get back to the specific question you asked, the cert petition that is currently pending provides, in some ways, a much more compelling case for the court to consider it than even the Masterpiece Cake Shop case did, for a couple of reasons. And one is three reasons. One is the cake shop in that case was driven out of business. They were fined out of existence by the state because they took the position that they did. The second is you can't reframe this case as a simple denial of service case, because the bakers served the lesbian couple, baked a cake for them for one of their mother's weddings who was having a second marriage and not a same-sex marriage. And so they had no qualms about serving gay people. Wasn't the issue. The only issue was whether or not they were willing to bake a cake or create a cake for a same-sex wedding. And the third fact that makes this somewhat more compelling than the Masterpiece Cake Shop case is that this bakery did only custom cakes. So they didn't have any sort of general goods that they would provide. The only things that they made were custom created for each specific customer. And so it does very sharply present the issues that were raised in Masterpiece Cake Shop.
But probably wouldn't surprise any of us if the court decides to pass and wait for another day.
Well, I was looking in anticipation of this panel at the court's First Amendment docket for this term, and there's virtually nothing on it.
Yeah.
There is one case out of Alaska raising this sort of interesting issue that arose because of the way the Supreme Court decided a similar case last term, or maybe 2 terms ago now. It was last term, about whether you can bring a retaliation claim for being arrested on the basis of your speech if there was otherwise probable cause to arrest you, where the retaliation is asserted to be coming from an individual officer rather than as a matter of municipal policy, a distinction that the court just made up last year. So that's the big free speech case. It's an interesting one, and I think it's a hard one. It was just argued, I think, earlier this week. But otherwise, the First Amendment docket is pretty bare, and even sort of massive blockbuster cases are not are fairly sparse on this court's docket. And I wonder if that. I mean, it's got to be in part in relation to the fact that they were short-staffed, and so they didn't want to take cases that would have ended in a 4-4 split until they had a 9th member. But I think that we may also see a moment like we saw at the beginning of the Roberts Court, where the court wants to avoid, for sort of institutional and political reasons after the Kavanaugh battle, some of the kind of big 5-4 splits that have characterized the last few terms of the court. So I wouldn't be surprised to see them duck it. On the other hand, if you believe strongly in the baker's right and you're a justice right now, you've got to be saying, for the reasons that Bob just said, this is a really compelling vehicle. This is a good case to make that ruling. But it is a hard case, and in part because you can characterize it as who has ever been forced to make a piece of art. You could also say cases prohibiting denial of service on the basis of a protected ground are extremely commonplace. And you can look at, what are the consequences of saying this is a work of art and you can refuse to do it? What about every restaurant, every chef that considers him or herself an artist of food? Can that person say, oh well, given that I'm making this art, I'm going to choose to do it only for the groups that I favor? And of course, that there are arguments to try to distinguish that case as well.
The best barbecue sandwich ever.
The best barbecue sandwich, yes, absolutely.
All of my sandwiches are works of art.
Yeah. So it's a tough issue. We may not see it quite yet.
The Bartlett case on whether or not you can bring a First Amendment retaliation claim for an arrest where there's probable cause is one of those cases where it is deceptively important. You would think that it's really narrowly focused because it's at an outdoor festival in Alaska. Some guy gets arrested and he mouths off to the cop, and afterwards he sues because he says, well, I was protesting. And you think, okay, come on, how important is that? But the problem is this. The capacity of the police to arrest someone in the protest example you cited earlier at the inauguration, it's not hard to find probable cause for an arrest, whether it's jaywalking, going 5 miles an hour over the speed limit, or anything else like that. And the problem is that for the arresting officer, he may not like the fact that you're photographing an area. He may not like the fact that you're a reporter, and or he may not like the fact that you're protesting, and can come up with any justification for spur of the moment and make your life a living hell. Now, if probable cause is all you need to cancel out the possibility of bringing a First Amendment case, you can imagine how easy it would be to really repress both protests and reporting and things like that. So, you know, this sleeper case, following one that was very narrowly and I think creatively decided last term, is really one to watch.
No, that's true, and I think, you know, in thinking of it as a little case, I'm thinking of the facts of this drunken guy at a drunken festival in Alaska, you know, struggling with a cop, but its implications could be significant for exactly.
Right, and it's following up on that particularly convoluted case that took place before the court last year, and again, those aren't the types of cases that garner like a lot of protesters around the courthouse.
That's right.
Significant.
That's right.
All right, we had, before the panel tonight, we had an inquiry in advance from somebody who was very interested in and we'll make this the last comment and then open it up to questions, the case involving the Wisconsin high school students who were taking a group photograph in front of their high school and seemed to be giving the Nazi salute collectively as a group, and the high school has now announced that it can't punish them because their action was symbolic speech protected by the First Amendment. Agree, disagree, make sense? Hard case, but right outcome?
I think, so essentially, public school students have slightly less in the way of First Amendment rights than people outside of school. What's called the Tinker standard is applied. The school has the right to punish or censor student speech if it's disruptive to the school environment or if it invades the rights of other students. And here, it seems that so this picture was taken about a year ago, and it looks like most of the students, not all of them, are giving the Nazi salute. I think that the school probably didn't discipline the students because there's just not a lot of facts about what happened or whether this was disruptive or not, you know, I mean, but then I will say that while I don't think that their decision is that unusual, because honestly it seems like they just discovered that this photograph was taken and they just don't really know enough about the circumstances around it, I would say that schools have used the substantial interference with the school environment thing and interpreted it very differently depending on what school you're in. You know, some schools would discipline students for far less than that, you know, for, say, kneeling during the national anthem or something like that. So it's hard to say that this is the correct or incorrect call. I mean, I can understand why they just didn't have enough information to really discipline the students for this, but it does seem that substantial interference can be interpreted pretty widely.
I think it was the right call not to discipline them. I think it's, you know, yes, absolutely students have been disciplined for kneeling during the national anthem, but they shouldn't be either. And I think it's important, you know, as the courts, as we're in this sort of volatile moment for the First Amendment, the courts get back to the Tinker standard as originally expressed 50 years ago and not water it down with, oh, that's disruptive and I don't really know about that. I think, you know, absent a serious actual disruption or an allegation that this was part of a broader culture in which racist or anti-Semitic or other types of speech were pervasive so as to constitute a violation of federal civil rights laws for other students, which is a possibility if this type of speech was severe and pervasive. I think you know, that's leaving them to their expression, however horrible and misguided, is absolutely consistent with that.
I generally agree, but it is so contextual, though. There was a case in a Seattle school district, I believe, where a student was wearing a T-shirt to school with an anti-gay slur, and he was asked to turn it inside out. The reasoning being this is invasive of the rights of other students, because if you are a gay student in that school and you see this T-shirt, like, it makes you uncomfortable to be there, which I understand. So it's kind of like with the Nazi salute. I don't know what context they were doing it in or who saw them or who was, you know, if this was disruptive to somebody's education or not, because you just have that photograph that's sort of in a vacuum, you know?
Except the difference here is that it wasn't a school event. And, if you have people marching up and down the halls during school giving Nazi salutes, that's a different set of facts and would call for a different outcome, I think. The Tinker case is one that, it's weird to think of it, but decided in 1969 is still the high point of the protection for student rights. And there you just have a young girl and her brother wearing black armbands, not even in protest, but more in mourning for the dead on both sides in the Vietnam War. And the school arguing that this would simply disrupt school operations, and the Supreme Court saying, no, we're not going to let this undifferentiated fear of disruption cancel out someone's ability to have this kind of silent protest. And while that was the high point, we've seen student rights, particularly at the secondary and elementary level, chipped away ever since. And one of the really unanswered questions is, to what extent does the school get to exert its jurisdiction over students when they're off school property? And the circuits are pretty much split on that question. The last time the Supreme Court dealt with it was in Morse versus Frederick, where you have someone with this Long Hits for Jesus sign, and there it was sort of an open question whether or not it was a school-sponsored event. Students had been released from school so they could watch an Olympic torch go through town. They were across the street. They were really off campus. And the court had to kind of stretch to say that this was a school-sponsored event so that it could exert jurisdiction over the students involved. Since then, you've had questions, mainly because of internet access and so on, that raise questions about whether or not student speech off campus is something that the schools can punish. And that's really an unanswered question. But here you have students, before they go to the prom, they gather for a picture, they give this salute that, some people are arguing they were serious about it, other people are arguing they were just goofing around, because after all, they're high school kids. Who knows what they were thinking. But in any event, it's problematic to say that we're going to make a decision about whatever they were thinking, and we're going to give the school the authority to decide whether or not that's a message we're going to punish. Because I think, frankly, schools have quite enough authority over students without giving them more.
All right, before I make a liar out of myself, I'm going to open it up to questions, as we have been promising for a while. Paula, do we have mics we want people to use, or? Yeah, why don't you take mine? We could start down here and then go back there. We'll work our way that way.
Hi, thank you for being here. That's great. I have a fairly broad and probing question about who is speaking through @real Donald Trump, and whether or not it's the Donald or the president, and kind of the future of Twitter as a public forum. What your thoughts are on that?
So I believe it was the FDNY. They made the decision that in that case that it was a public forum, and we'll see where that goes. But I think when you're looking at government officials and their usage of social media accounts, there's a lot. I think you can see in the way that they're using it, if they're using it as a public forum versus as a private individual, what they post, what kind of discourse they're having with their followers or their Facebook friends or whatnot. How what resources they're using to maintain the account. I think in the case of the real Donald Trump, he uses his Twitter account to announce things about policy, and then sometimes enacts these things. So that was that did not weigh in the favor of it being a private account, even if it's posted on a private platform.
Yeah, and it also depends on whether or not you're talking about the ability to have access to the forum as individuals, or whether or not you're talking about having some way of regulating the speaker, the originator of the account. And there are a couple of cases now, and one of them that my colleague Lisa Zeigerman handled in Maryland, involving whether or not Governor Hogan could simply terminate the ability of individuals to be on his official site if they said things that he didn't like. And that case was ultimately settled. But the use of social media in that context has been determined to be more like a public forum. And whether or not the government speaker is speaking as government or speaking as an individual is something that is much more problematic.
And I think this is going to play out over several cases and possibly many years. I mean, the Trump, for the reasons Lata said, the Trump case is a great one for the plaintiff because Trump uses the account in such an official way, in such a policy-making way. On the other hand, there are some really difficult questions about the application of the forum doctrine. If you read the district court decision going against the Trump administration, you notice the judge defines the forum very particularly. What the forum is, according to the judge in that case, is the interactive space created by Twitter among Trump and Twitter users, right, but not the tweets and not the timeline of the tweets. And so I think, there may be some very, very fine factual nuances that end up driving a lot of the results, but it's really hard to know where this line of cases is going to lead.
You also have an aspect of it where you can ban people from a forum for a viewpoint neutral reason. Like if I'm having a town hall, I can say that you have to wear pants, otherwise we're not going to let you in. And similarly, you could say, well, yeah, more or less. And similarly, you could say that, well, I don't allow people who use profanity. No kilts, come on. Crossing the line. I could say that people who use profanity, I'm going to block them, and that's my viewpoint neutral rule. It gets to the point of being unconstitutional when you're banning people for their viewpoints, for instance, for disagreeing with what you have to say or your policy. So in the case of that real Donald Trump, the evidence shows that he was banning people after they said something critical of him. But I could see this becoming more murky in other cases where, maybe you're banning everybody who's just being too insulting, and in that case, is that really viewpoint neutral? So I think there's a lot of different contextual factors that we're going to see.
I have a question about the NFL. Do you think that they would be afforded a First Amendment right in terms of the people's right to kneel, either Trump's interjection or the money going to concussion studies or tax exempt status, or is it a private entity?
The First Amendment says that Congress shall make no law, not that the NFL shall make no rules. It's a private entity. It can set whatever rules that it wants in terms of how its players should behave or whatever. Well, not necessarily any rule it wants, but it certainly isn't the government when it comes to determining what kind of symbolic expression is permissible on the field. I think that if you were to talk about sanctioning the NFL through, controlling their tax exemptions or tax status, then that government action is problematic. Because then you're deciding what action they should take and using the mechanism of government to push them in that direction. And, that I find difficult.
Well, we raised the question once before on one of these panels about whether if you're talking about municipally funded stadiums, does that change the equation at all, or is it still private employment relationship?
But that's the same question that comes up in the context of art galleries and museums that have public funding, and do you argue that changes the First Amendment balance? And libraries too. I mean, they're also publicly funded, and does that give the government the ability to then determine which books go in the library, separate for political reasons and separate from simply curation decisions? Public funding usually makes these issues more problematic, but it doesn't change the fundamental underlying First Amendment question.
I do wonder, though, whether whether a law regulating the NFL as a business would raise First Amendment problems as long as it was content or viewpoint neutral. For instance, if the government said the NFL shall not take disciplinary action against a player for expressing or declining to express a viewpoint. I mean, you know, and in the same way that there are certain states with common law rules have created causes of action for wrongful discharge when businesses retaliate against employees for their speech. I could imagine that, as long as it was properly drawn, being permitted, particularly since the NFL isn't an expressive association like the Boy Scouts or like a parade.
Those are difficult lines to draw, and I think if there were an attempt to try and decide, to try and force the NFL to take a position one way or the other, that's a case I'd take.
Let me go back to the beginning when Bob talked about intent or motive in the context of the First Amendment, and Scott then kind of invoked the travel ban, and stipulate I'm neither a lawyer nor have a good memory. But if I remember the travel ban, the Supreme Court basically said motive was not an issue that they considered. Basically, they followed the law. And what the presidential tweets about a Muslim ban, etc., was not really considered. And my question then becomes, if the travel ban provides some guidance, how does that affect the First Amendment case?
Well, I think it's important to recognize that the travel ban that was upheld was the third version, and the first two were almost across the board and invariably at the circuit level struck down by the courts because there wasn't enough of a patina of official legitimate reasons around them. It was just discriminatory, and there was some variation in the reasoning among the different courts, but I don't think the fact that the Supreme Court ultimately upheld the travel ban against the charge of intentional discrimination is necessarily going to be dispositive in a First Amendment case. First, because this Supreme Court, this group of justices, is much more sympathetic to the First Amendment than it is various claims of discrimination. And second, because the travel ban happened in the context of an area where the executive gets particular deference, which is determining who comes into the country and under what circumstances. So I don't think my point in making the comparison was just that motive became a central issue and led to a number of the administration's early losses on the Muslim ban before they finally got one upheld. In a similar way, they've exposed themselves to the Pan American suit over the blocking of the merger and the regulation of Amazon's postal rates because Donald Trump has been so explicit about his motives, and I don't think those motives are gonna play well or be so easy to brush aside in this First Amendment context if the case reaches the Supreme Court.
And that's the thing. I mean, what the Supreme Court said in Hawaii versus Trump is that you can consider that extrinsic evidence. You can look at the motive, but as the court pointed out, this is an area where there's an executive order on immigration where the president's power is at its highest, and so that if there is a rational basis for upholding the regulation, it was going to do so. Now, it was a First Amendment case in the sense that the allegations were made that this was discrimination toward religion, but at the same time, where there is that extrinsic evidence versus a regulation that can separately be justified for other reasons, the court did defer to the executive branch. But if you're dealing with a First Amendment retaliation case, where retaliation against specific speech and intent is the threshold issue, the court said you can look at that extrinsic expression of intent through tweets or press conferences or whatever else you might have for this president. And then I don't think you get the same level of deference. You're right. I mean, where then it's a question of if you can establish what the motive was, then it becomes the government's burden to prove that it was done for a valid reason.
Let me remind folks on the webcast that you can submit questions through the drop-down box that says questions, and we'll be happy to try to take those. Do we have other questions in the room? Austin.
So in Justice Kagan's dissent in Janus, she mentioned that she's afraid that the Supreme Court is going to turn the First Amendment into a sword and kind of do some policy making, kind of strike down things that might touch speech in ways that other justices might not like. Are you worried you see a modern First Amendment trend that tends to get more involved where other courts have allowed government regulations that have regulated speech? It's kind of on a larger level.
Weaponizing the First Amendment was her phrase.
Yeah, it was a phrase. It's a bumper sticker, not an argument. It's almost hard to know how to begin on this one. I mean, that's what the First Amendment is for. It is for protecting against the use of government power to either censor speech or compel speech. In that sense, whoever happens to use it and can make the case that their speech has been affected, it is the weapon that the Constitution provides. So the term weaponizing the First Amendment is just a pejorative that is being used. Mainly it was being used by academics, and now it's been picked up by Justice Kagan in the Janus context. And you can argue about whether or not compelling union dues is compelled speech. And that's a whole separate conversation. We could spend an entire panel on that. I tend to think that if you are compelling people to support organizations that are engaging in political activities, that's compelling speech. But, this notion of whether or not that's weaponizing the First Amendment is I think, kind of silly.
Well, can I just follow up to say, I think she's
we don't allow follow-ups.
Turn into
an advantage.
I think she would be worried because there was First Amendment precedent that allowed for the requiring of the endorsing the speech. So I guess from that perspective, are we weakening old precedent to, I guess, use the First Amendment in a different way? Is it being used differently, or is that just kind of an anomaly?
Well, the Janus case did overrule Abood, which had said that you can compel union dues for unionizing activities, but not political activities. And the holding in Janus was that division had not been workable over the years. And part of the problem is that a lot of people will view what the court does in political terms. It's kind of like a national Rorschach test. Is it good for the unions? Well, and again, keep in mind, public sector unions. It's government, for government jobs, not for private jobs. And so you have a measure forcing people to support that union. Frankly, it's a requirement that private unions survive without. And I don't think it's necessarily going to affect the concept of unions, but people will line up on one side or the other of that question, whether or not they consider themselves to be pro-union or anti-union, when I think it's really just a question of whether or not a government entity can force someone to support an organization for speech purposes.
There's a fair likelihood that the court will take one of the mandatory bar dues cases.
That would be interesting.
Even more generally, I mean, I think the notion of weaponizing, I mean, it's all in the eye of the beholder, First Amendment or any amendment. I mean, there's always this concern and this debate that's been going on basically since we've had judicial review in the United States, that the justices will turn principles that are supposed to be neutral toward their preferred political ends, regardless of what the inherent meaning of the principles is. And it's it's a charge that gets leveled always on all issues. It sort of depends on whose ox is getting gored at the moment. But as far as Justice Kagan's use of that phrase goes, I did not see Janus, maybe like Bob, I didn't see Janus as a particularly shocking or strange application of the First Amendment. I mean, it was a hard case, but I thought, it certainly fits within the logic of many prior decisions, even though it obviously overruled one. If I were asked to identify somewhere where the court was weaponizing, let's say, in favor of a big business agenda, which I think is largely what folks on the left are talking about, probably would have picked a different case. In particular, I'm thinking of the Sorrell case, which permitted data mining under the First Amendment in the face of a privacy law that actually served a pretty important interest. And certainly in my position at the ACLU, being concerned about both speech and privacy, it's one of those moments where sort of values conflict, and I would have expected privacy to win out there.
Except in Sorrell, the court only restricted the use of this prescribing information, anonymized information, by the way. It didn't reveal anyone's private prescription habits. It was really just looking at aggregate data to allow pharmaceutical companies to target their sales pitches to doctors. But the problem with the law is, if you weren't a pharmaceutical company, have at it. You could have the data. You could use it for all kinds of other purposes. And the state decided to pick and choose who could use it based on how they favored their speech.
Well, it was based on the use, based on the type of use that they expected to occur.
I'm going to allow the last question, I think, to go to a person on the internet, and then we'll wrap up. So the question is, actually, I just lost the question. Question is getting long. I have to scroll. Sorry. The question was: does the First Amendment extend to the use of Twitter, like Trump's use of Twitter, in international situations? The questioner says, taking, for example, the case of Trump and Macron, which happened this month after Trump's visit to France, are First Amendment rights in such cases, do they extend internationally? And is there any protection there?
I found something on the web for cases. Did they extend internationally?
Who needs us? We've become obsolete.
So there's actually another question on the internet, but is there an answer to that one? Does the First Amendment apply to the use of Twitter in international context?
I don't understand the question.
Hard to know.
Well, I mean,
Is the question whether you could be liable for tweets in another country, or is it that?
It's not clear. Let me take the other question, and
maybe you should have asked Jerry.
Maybe the questioner will clarify. So the other question is: in these turbulent times, can attorneys be regulated as officers of the courts in the speech that they use, for instance, against the president, or suffer disbarment so long as no harm is done or threatened?
Well, we are regulated as officers of the court. I mean, there are certain ways that our speech is regulated, both in terms of what we can say in court and according to Kenning's professional responsibility out of court. In terms of political activity, actually, it used to be much more common where you would have political questions as a condition of bar membership. Have you ever belonged to a subversive organization? Things like that. Most recently, certain state bars are considering this model code. What is it? 8.4, right? Okay. That basically is a civility code for lawyers, which, again, in terms of having those kinds of regulations for in-court activity is not that much of a problem, but to have it for anything that is in any way related to the practice of law, meaning you go to a bar function, you have a dinner or whatever, and if you say anything that violates the civility code, that can be sanctionable as professional misconduct, that is highly problematic. both in terms of the overbreadth and vagueness of the standards and also in its reach to beyond the confines of being in court.
I guess I wonder
being on this panel and being characterizing your litigation opponent's position as outrageous.
Yeah.
Is that uncivil? If so, I'm in big trouble.
Oh,
I wonder if the questioner here is asking whether you could be disciplined by the bar for making statements highly critical of the president in court, in a court case, or in some other context. I think that seems to be the question.
it is kind of interesting because there have been arguments about professional speech as a category of speech, like can your state bar association discipline you for this or tell you that you can't call yourself an attorney unless that happens? So there's some who view that as sort of a less protected form of speech, like commercial speech, that speech that's related to your business and it can be regulated by the state in ways that usually your political speech would not. And then there are others who say that those distinctions are meaninless.
I think for the first time in this last term, the court addressed that issue and said there really isn't a separate category of professional speech doctrine where we're going to provide less protection. But you're right, those questions about regulating professional speech have grown out of the commercial speech cases.
All right, I'm going to wrap things up. I have three things to say. First of all is I want to thank the staff of the section of Civil Rights and Social Justice. Paula is here, Ali is back there. They do a wonderful job and make all of this happen, and I am very grateful for their help and support, so thank you. Second of all, actually I lied, I have four things to say. Second of all, there is a reception outside, which you are all invited to join as soon as we wrap up with the other two things I want to tell you, which are both kind of commercial messages. First of all, the ABA president, Bob Carlson, has declared that the Law Day theme in May 2019 is free speech, free press, and free society. So the ABA is recognizing the importance of the issues that we're talking about tonight and celebrating that as the theme for Law Day on May 1st. And then the last thing I want to say is if any of you happen to be at the ABA mid-year meeting in Las Vegas, we are doing a panel on the 50th anniversary of the Tinker case on January 26th in the afternoon as part of the programming for the ABA mid-year meeting. And with that, a big thanks to our panelists and thanks to all of you for being here.
For the line guarantee that we have.
I'm trying. I've asked her, and she said she would do it, but we don't have any budget.
We will be live streaming it as well on our webinar platform, so that you can watch.
I need to see if I can find some money to bring her out. Sure.